What can you copyright? Title 17 of the United States Code, Section 102, lists 8 categories of original works that are eligible for copyright. 1. Literary works. 2. Musical works, including any accompanying words. 3. Dramatic works, including any accompanying music. 4. Pantomimes and choreographic works. 5. Pictorial, graphic, and sculptural works. 6. Motion pictures and other audiovisual works. 7. Sound recordings. 8. Architectural works. This list, while broad, actually includes a far more extensive range of work than the average citizen might imagine. One example of copyrightable work that may not be immediately obvious from this list is software. Why is software copyrightable? An appellate ruling of the 1983 case of Apple versus Franklin held that software was a kind of literary work and therefore eligible for copyright. The court noted that the Copyright Act defined the term literary work as follows. Literary works are works other than audiovisual works that are expressed in words, numbers, or other verbal or numerical symbols or indicia, regardless of the nature of the material objects, such as books, periodicals, manuscripts, phonorecords, film, tapes, discs, or cards in which they are embodied. Based on this definition, the court determined that a computer software program is an appropriate subject of copyright. Note, however, that sometimes works of authorship, such as software, include potentially patentable processes. Copyright does not extend to those processes. Beginning in the 1990s, software companies increasingly began to patent those elements of their new software that could be described as patentable processes in order to secure the stronger protections of patent law. Software is just one example of how the courts have tended to interpret the 8 categories of eligible subject matter quite broadly. Just as technology drove the expansion of eligible subject matter into ever new realms, first photographs and then motion pictures, the courts have also expanded the definitions of all 8 categories of eligible subject matter to include new types of work, such as maps, games, puzzles, toys, fabric design, and many other creations. However, not everything is copyrightable, far from it. You may remember that patent law makes a sharp distinction between ideas and their application. For example, you cannot patent an idea for a better mousetrap, but you most certainly can patent a new, non-obvious, and useful apparatus that catches mice. Similarly, copyright law differentiates between ideas and their expression. You cannot copyright, for example, the idea of an epic space opera in which a mystical cadre of Jedi Knights wielding laser swords battle galactic evil, but you can copyright the particular expression of that idea in the screenplay and motion picture Star Wars. Because it is an abstract concept or idea, Einstein's formula E=mc² is also not copyrightable. That's because the formula was derived from observation of natural physical laws and must remain in the public domain. If such a formula were subject to copyright, private intellectual property rights could create a blockade, preventing scientists and mathematicians from continuing their research and teaching. Also not copyrightable are names, addresses, and other facts unless they are creatively compiled. That's why a phone book cannot be copyrighted, whereas the creative compilation of facts in a Chinese-American phone directory listing bean curd and bean sprout shops may be copyrightable under certain conditions, as a judge ruled in the 1991 case Key versus Chinatown. To be copyrightable, a creative work must not only be expressed in a tangible form that allows it to be seen or copied, but it must also be original. The requirement for originality in copyright has its parallel in the requirement for novelty in patents. However, this parallel works only to a point. A copyrighted work need not be novel in the strictest sense to be considered original. As Arthur R. Miller and Michael H. Davis explain in their textbook on intellectual property for law students, the author's ideas and themes may have appeared in earlier works. Indeed, much of the expression may have been produced before, but copyright will be available to this second author if his is a work of independent creation. To reiterate, in order to be copyrightable, a work of authorship must not only fit under one of the 8 broad categories of eligible subject matter, but it must also be independently created, expressed or fixed on a tangible medium that can be seen or copied, creatively authored or compiled, not a fact or abstract idea.